High Court of the Union, opinion, July 20th, 2024. Ho v. Wallace Administration. Case brief. On July 9, 2024, Plaintiff Fat Ho of the District of Reconia filed suit against incumbent President David Wallace and his administration over the constitutionality of executive orders 07,012,024 and 07,062,024, codenamed the Vietnamese bans. Under Executive Order 07,012,024, immigration and travel to the United Districts of Reconia has been prohibited to nationals of the following countries: Vietnam, Laos, Cambodia, Myanmar, Burma, Malaysia, Brunei, Indonesia. 5 days later, Executive Order 07,062,024 was signed into effect by President Wallace, effectively banning those with ethnic descent from the aforementioned 7 countries from immigrating to or visiting the United Districts of Reconia, unless they were to recite a pledge of allegiance to the UDR before a customs enforcement office prior to the immigration or travel. The purpose of this pledge, according to President Wallace, was to prove their loyalty to the Union and to respect Reconian laws, customs, and traditions, in addition to the political systems of these countries differing significantly from that of our nation. Both of these executive orders are set to expire on December 31st, 2026. Neither of these executive orders affected those with nationality or descent who were already present in the UDR prior to the signing. Fat Ho, a naturalized Vietnamese Reconian, immigrated to the UDR in August 2018 as the lead plaintiff in the case. Ho did not believe that President Wallace's executive orders were constitutional and challenged them on the basis that they were unconstitutional. Syllabus, the presiding officer of the Union, has historically played the role as a peacekeeper and a preserver of the nation's well-being. During times of national health crisis, such as JIFAC in 2017, which saw an unprecedented level of legislation passed to combat the crisis, including limits on the general freedoms of Reconian citizens and greatly increasing the scope of powers of the Reconian federal government. The Reconian-Normanian Thaw Act banned travel and immigration to the UDR from Normania on the basis that Normanian nationals posed a national security threat to the UDR, and therefore must be banned to safeguard the nation. The law, passed in August 2017, was not challenged in courts nor overturned by a statutory body. It was not until June 2020 when former President Underwood overturned the act by executive order. During the SIAC crisis in February 2019, former President Ibuki Miyota also sponsored and passed legislation that helped curb SIAC, such as Executive Order 21,019, which limited cultural and economic ties between the UDR and SK 1998, which was the largest economic partner of the UDR at the time, as SK 1998 was believed to be harming the well-being of Reconian citizens. Under Reconian common law, we will apply the President's previous roles as a caretaker and a preserver of well-being for our citizens to the O.V. Wallace Administration case. President Wallace has determined that people of certain nationalities and ethnicities pose an intellectual threat to our nation, but most important and relevant to this case. People of these nationalities and ethnicities are known to be a trigger for the Bravo bust, a societal disorder as recognized by the Bureau of Reconian Anxiety Diagnostics, BRAD. The Bravo bust is considered to be ongoing and has been negatively impacting the well-being of many Reconian citizens since 2022, according to the BRAD. Therefore, with best judgment, we can presume that President Wallace signed Executive Orders 07,012,024 and 07,062,024 as a solution to the Bravo bust in an attempt to promote the well-being of Reconian citizens. Ruling, the High Court of the Union sides with the defendant in this case, the Wallace Administration. Our reasoning lies on the President's historical role as a caretaker and preserver of well-being, considered to be one of the President's unofficial roles in their duties as the leader of our nation. Executive Orders 0701062024 and 07,062,024 are constitutional under the Charter of the Union, as they are well within the scope of the President's power. However, Executive Orders 07,012,024 and 07,062,024 are only to remain in effect so long as the Bravo bust is considered to be an ongoing national crisis. The rationale behind our decision is that actions undertaken by a president due to an ongoing national crisis, recognized as such broadly by many government institutions such as the BRAD, are constitutional so long as they are within the scope of authority vested in them by the Charter of the Union. The key word here is ongoing. Once the Bravo bust is determined to no longer be a national crisis, these executive orders 07,012,024 and 07,062,024 must be signed out of effect or will no longer be enforceable by our customs enforcement agency. The court would like to reinforce that the president cannot arbitrarily decide upon countries from which to ban nationals or those with dissent. And this ruling does not set precedent for future immigration bans based on countries that the president does not like.